welcome to the FedSoc Forum webinar call. Today, June 3rd, 2025, we're delighted to host a discussion on emerging issues in the use of generative AI, ethics, sanctions, and beyond. My name is Kayla Kleist, and I'm an Associate Director of Practice Groups here at the Federalist Society. As always, please note that all expressions of opinion are those of the experts on today's program, as the Federalist Society takes no position on particular legal or public policy issues. Now, in the interest of time, we will keep our introductions of our guest today brief, certainly more brief than their careers would deserve. So I highly recommend that if you're interested, you check out their impressive full bios at fedsoc.org. I'll go ahead and introduce our moderator, and then I'll leave it to him to introduce our panel. Today, we're delighted to have Judge Brantley Starr join us as our moderator for today's conversation. Judge Starr has served as a federal district judge in the Northern District of Texas since 2019. Before that, he was a deputy first assistant attorney general of Texas and served in various roles in the Texas Attorney General's office. He clerked for Don Willett, then on the Texas Supreme Court, and he teaches originalism at Texas A&M University Law School and at SMU's Dedman Law School. And I'll leave it there. A last note before I get off your screens. If you have any questions throughout the program, please do submit those via the question and answer feature, likely found at the bottom of your Zoom screen, so they'll be accessible when we get to that portion of today's webinar. I'll ask that all questions submitted there, A, pertain to this discussion, and B, end with a question mark. With that, thank you all for joining us today. Judge Starr, the floor is yours.
Okay, Kayla, thank you for having us, and thank you to FedSoc for putting on this good webinar with an outstanding panel. I just want to say that the bio that you gave of me was 100% accurate. Anytime I go talk about generative AI, then I check my bio on ChatGPT to see if there are inaccuracies. And the first time I did that 2 years ago, it was horribly wrong. About a year ago, it thought I clerked for Sam Alito. I actually clerked for Don Willett. It also thought I clerked for Jerry Smith on the Fifth Circuit at one point. So I actually took a screenshot of that, sent it to Judge Smith, and he said, "I'm so sorry I forgot you clerked for me. You should come to my future clerk reunions." So hallucinations can bring people together in positive ways like that, or negative ways like sanctions hearings. So we'll get into all that here in just a moment. But I need to introduce our panelists. So the first one we'll hear from is Phil Seckler at Alliance Defending Freedom. He focuses on academic and religious freedom issues there at ADF. Earlier in his career, he was at Williams and Conley, and he was also a partner at the litigation boutique of Robbins Russell. He's also taught professional responsibility at Penn State, Scalia Law, and Georgetown Law, which makes him uniquely suited to talk through ethics issues as we approach the generative AI issue. He also wears a tux quite well, and I need to give a full disclosure that Phil and I are on the board of the Texas A&M University Journal of Law and Civil Governance together. That doesn't mean we agree on everything in life, but we have plenty of things to talk about. After we hear from Phil Seckler, we'll hear from Lauren Mills. Lauren is founding partner at Werther & Mills, LLC. He focuses on complex commercial litigation, white-collar prosecutions and investigations, IP litigation, First Amendment litigation, and corporate governance and shareholder issues. In short, he can do everything for you but the drafting of your will. But after we all improve with generative AI, in a year, he can do that too. Lauren is a very busy man, and he took time out of actually taking a deposition today for a long lunch break to cover this webinar. So thank you, Lauren, for making the time. And then last but never least is Professor Eugene Volokh. He's the Thomas M. Seibel Senior Fellow at Stanford's Hoover Institution and the Gary T. Swartz Distinguished Professor of Law Emeritus at UCLA Law School. I count that as two offices of emolument. Good thing you aren't president, Professor Volokh. He did not write the First Amendment, but he's written everything worth reading about it. And he's the one who scared the bejesus out of me a couple of years ago by introducing me to this topic. He was presenting at the Fifth Circuit's Judicial Conference. I knew nothing of AI biases or hallucinations, and by the time his talk was over, I had the talking points of a draft order regulating the use of AI. I knew only that I didn't know what I was talking about, so he was gracious enough to workshop that with me over the course of about a month, and then I credit him with being the genius behind that first court regulation of the use of artificial intelligence in court, and we have a lot more regulations since then that we'll talk about. I'm not unique in relying on him. We've got 8 SCOTUS citations to his work and several hundred court opinions that cite to his work as well. So what I wanted to do is start off with you, Phil, and see if we could hear your thoughts on ethics issues surrounding generative AI. And then we can have some sort of interaction from our other panelists, Lauren and Eugene, after that. And then we'll go to a practitioner's view with Lauren, and then save our remaining topics for the end with Eugene. So, Phil, what can you tell us, given that we've got some movement from the ABA and the states in this space?
Yeah, so the model rules of professional conduct don't specifically address artificial intelligence, but as you noted, the states in the last couple of years have had a lot of activity through ethics opinions on AI, and last July, the ABA issued opinion number 512 addressing the use of AI in the practice of law. And the bottom line of all of this activity is that the existing rules of professional conduct really are triggered by the use of AI. And so lawyers must think seriously when they're using AI about their obligations. Now you can violate pretty much every rule of professional conduct with AI, but I think the most important ones to consider here are competence, candor, confidentiality, and supervision. And so that's what I'd like to address. First, on competence. Must a lawyer use AI to be competent? We're probably all familiar with the infamous comment number 8 in Model Rule 1.1 that says lawyers must keep up with changes in relevant technology to maintain their professional competence. But in opinion number 512, the ABA said we're not yet at the point where lawyers have to use AI. The ABA noted it's conceivable that at some point we'll be there where lawyers have to use AI to be competent, but we're not there yet. Even so, the ABA suggested that lawyers should be aware of available tools to make an informed decision about whether to use them. And a number of state ethics opinions basically say the same thing. You don't need to use AI to be competent. But if you do use AI, what level of technical competence is required? Well, the Texas Ethics Committee answered that question well. And it said, if a lawyer opts to use a generative AI tool, the lawyer must have a reasonable and current understanding of the technology, because only then can the lawyer evaluate the risks of hallucinations or inaccurate answers, the limitations that may be imposed by the model's use of incomplete or inaccurate data, and the potential for exposing confidential client information. And as for the risk of inaccurate answers, the DC Legal Ethics Committee had some good advice on that point. It said, generative AI tools are not search engines. Lawyers should not assume they are. They are trained on limited data sets and might not be complete or up to date. In fact, they're not even programmed to accurately report the content of information in the data set. Their purpose is to predict content. And AI products can hallucinate, as you pointed out, Brantley, which means they make up things that don't exist, like false case citations. And they build on prior interactions. So if they make up cases that don't exist, those fictional cases can become part of their data sets for later users. They are simply not a reliable substitute for traditional site checking. Another issue with AI tools is that many are designed to collect and use information from users in later interactions, which of course means it could include client information that you put into it. Other problems with AI, as noted by a Kentucky ethics opinion, are AI may struggle to grasp complex legal issues and concepts, and that can produce misinterpretations. AI models trained on biased data may perpetuate biases in legal decision-making. And AI tools lack transparency because they're essentially black boxes, so it's hard to understand how they arrive at conclusions. So how does a lawyer gain technical competence on AI? Well, the ABA offered this advice. First, you can read about AI tools targeted at the legal profession. You can attend CLE programs focused on AI tools. You can consult those who are proficient with the technology. And remember, this is not a static exercise because it's a fast-paced evolution of technology, so lawyers must remain vigilant. As far as reading goes, the New York Bar's AI Task Force issued a report in April 2023, and Appendix B of that report has a great list of resources to learn about AI. And the DC Bar also identified some things lawyers should consider about specific AI tools they are using, including what's in the news about that AI platform. Has it been tested for its intended use by disinterested third parties? Have other legal professionals that you trust tried it? And also you can do this. Ask AI to do something that you've already done yourself and compare the results. The bottom line is that a lawyer cannot abdicate his responsibilities by relying solely on an AI tool to perform tasks that rely on professional judgment. And failure to perform appropriate verification of AI output can definitely violate Rule 1.1. So that brings us to candor. Can a lawyer violate his duty of candor to the court by relying on AI-generated output without verification? Well, of course, the answer is yes. Rule 3.3 prohibits a lawyer from making false statements knowingly of law to a court, but Rule 8.4c prohibits a lawyer from conduct involving any misrepresentation. And the ABA said that even unintentional misrepresentations generated by an AI tool are prohibited misrepresentations. And those could include citations to non-existent opinions, inaccurate analyses of authority, and the use of misleading argument. The ABA said, in judicial proceedings, duties to the tribunal require lawyers, before submitting materials to a court, to review AI outputs, including analysis and citation to authority, and to correct errors. And state ethics opinions say the same thing. Here's North Carolina. A lawyer's signature on a pleading certifies the lawyer's good faith belief as to the factual and legal assertions therein. So when a lawyer adopts an AI tool's product as her own, she remains professionally responsible for use of that product. Now, of course, we all know of many examples of lawyers being disciplined or sanctioned because they submitted AI output to the court without checking it, and it ended up being false. One of the first such cases was Matta versus Avianca from the Southern District of New York in 2023. There, the lawyer wrongly thought that ChatGPT was a super search engine with access to a comprehensive law library. It's not. His AI-generated brief cited 6 cases that don't exist. They were completely made up. And when opposing counsel in the court asked questions about those citations, what did this lawyer do? Well, he asked ChatGPT whether the cases were real. And ChatGPT said they were, that they could be found through Westlaw. That also was false. But that's how the lawyer responded, and the judge was not impressed. So the lawyer was sanctioned with a fine, a duty to notify his client about the sanction, and a requirement that he notify the judges who were falsely identified as the authors of fake opinions. Stanford University researchers have found that large language model AI tools hallucinate 75% of the time. And the May 24th article in The Guardian actually cites a database, it links to a database that identified 106 instances of AI hallucinations in court documents, resulting in fines, suspensions from practice, and requirements to take additional CLE. 2 important points about these sanctions. First, it's not just the lawyer who uses the AI tool who's at risk. It's everyone on the pleading. So in February of this year, the named partner of a prominent firm was sanctioned for the submission of fake AI-generated authorities, even though his contribution to the brief was simply the basic idea for the motion. Why? Because his name was on the pleading, and under Rule 11, that's enough. Second, it's not just legal argument that get lawyers into trouble. Lawyers have a similar responsibility over their experts and other witnesses. So recently, the state of Minnesota, in defending against a challenge to its deepfake law, submitted the declaration of an expert on the dangers of AI and misinformation. Ironically, that declaration cited 2 fake academic articles because the state's expert on AI used AI to create the report and didn't verify the output before submitting it. The court excluded the declaration in its entirety and refused the state's request to submit an amended one. And then the court suggested that Rule 11 imposes a duty on lawyers to ask witnesses whether they have used AI in drafting their declarations, and if so, what have they done to verify the truth of any AI-generated content. We should all start doing that. So let's turn to confidentiality. Does AI pose a risk to the confidentiality of client information? Yes, of course. If you put information into it that relates to your client, it could be disclosed to others in your firm for use in other matters. It could be disclosed to people outside your firm, and it could be retained by the AI tool for an indefinite period of time. As a Texas ethics opinion said, these are self-learning tools, which by their very nature store and incorporate user input into existing data sets to improve their operations. And in fact, the policies of these tools often say just that. For example, ChatGPT's privacy policy makes it clear that it stores your input and then uses it later to provide service to other customers. Thus, lawyers who input client information or even their own mental impressions about a case into an AI tool risk violating their duties of confidentiality. They could disclose information in breach of Rule 1.6. They could end up waiving the attorney-client privilege. So how should a lawyer handle that risk? Well, evaluate first the chance that information will be disclosed improperly. It's a facts-driven analysis because each AI tool is different. Some tools actually have a zero data retention policy, which means they retain neither the inputs nor the outputs of an interaction. And of course, a lawyer would be well advised to consult with IT experts in considering the security of an AI tool. And lawyers should use reasonable care in selecting AI vendors. As a North Carolina ethics opinion suggested, a lawyer should ask, what is the experience, reputation, and stability of this company? What security measures are in place? What will happen to any info if the company goes out of business, changes ownership, or if services are terminated? And the ABA said, as a baseline, all lawyers should read and understand the terms of use, the privacy policy, and related contractual terms of any AI tool they use. And if client information will be shared with an AI tool, Rule 1.6 requires that a lawyer get informed consent from the client. That means the lawyer has to explain to the client why the tool is being used, the extent of the risk, the particulars about the kind of information that will be disclosed, and the ways that others might use that information to the client's disadvantage. But the DC Bar said clients should not be asked to consent to wide-ranging disclosures that could waive the attorney-client privilege or make sensitive information available to third parties. So that takes us to supervision. Rule 5.1 requires those running a law firm to make reasonable efforts so that it has reasonable assurance that all lawyers comply with the rules. So given the scores of problems we've all seen with lawyers improperly using AI in violation of ethical duties, do you think firms are required to adopt policies to address the use of AI by their lawyers and staff? The answer to that is yes. The New Jersey Bar's Task Force on AI issued a report last May, and it said all law firms should adopt an organizational AI policy. And Appendix 2 to that report provides such a sample policy. A California ethics opinion likewise says managerial and supervisory lawyers should establish clear policies regarding the permissible uses of generative AI and otherwise make reasonable efforts to ensure a firm's overall compliance with the rules. And the Kentucky Bar said, at a minimum, those policies must make verification of every AI-generated citation mandatory. Kentucky also said, although policies are an important first step, they're not the end of the lawyer's duties. A firm should create a culture of security and privacy, and a firm must train everyone on its AI policies. So when using AI, a lawyer should keep those four things: competence, candor to the court, confidentiality, and supervision top of mind.
Bill, phenomenal coverage on the span of ethics. So, Eugene, we've covered a lot here under the ethics banner with competence, candor, confidentiality, supervision. I don't want to wait till the very end to get your thoughts. What do you want to add to our waterfront on ethics?
Well, I agree with basically everything that has been said so far. Don't have much to add, but I do have a apparently non-AI, at least unless they are using AI and not telling me in this respect, terms and connectors query on my screen right now from Westlaw. It's my query for finding new cases, which mention AI hallucinations. And here are the dates, just so you get a sense for the most recent such incidents. one from June 2nd, yesterday. Then before that, May 30th. Then before that, May 29th. Before that, May 28th. Before that, May 27th. So I don't think I need to keep reading. The total results are actually about 200 plus, although there's some false negatives. The 5 that I gave you over the last week, basically, are not false negatives. They are courts actually saying that they have spotted what they believe is non-existent citations likely stemming from AI. So this is basically on a rate of 1 per weekday, and that is just in Westlaw accessible cases. Of course, as we know, the great bulk of all cases in the country are state trial court cases, which sometimes make their way to Westlaw, but fairly rarely. So we're talking that every day, I'd say this is 1/10 of the cases in which this happens, just picking a number, but it seems pretty clear that there are going to be a lot more that aren't on Westlaw, or that aren't even spotted, or that the judge spots but doesn't write an opinion about it. We're talking about every day there are probably 10 instances of hallucinated citations being used. Now, to be fair, about half of the ones that I've seen are from pro ses. But that means half are from lawyers. And it ranges from people at basically solo practitioners to people at top law firms. There was a case involving basically a top 20 by size American law firm whose filings, which were filed together with a smaller but very prominent and respectable a California litigation boutique, contained hallucinated citations, and of course it was tremendously embarrassing for the lawyers involved. You know, there are sanctions that are issued. I've seen some, I think, as high, I want to say, as $16,000, maybe even more. But you know, I think for most of us, we'd rather pay $16,000 than have a court opinion which says Eugene Volokh filed a document with hallucinated cases. Let me stress, that's a hypothetical opinion. I haven't done that, and I hope never to do that. Although in one of the cases that I've been litigating, and I don't litigate a lot, but one of the cases I was litigating, the opponent filed the document with hallucinated cases. So this is happening all over. The question I even ask is, don't lawyers cite check anymore? Don't they have associates or paralegals or even secretaries who are trained to cite check? It's not rocket science. And if you lawyers say, well, we don't have Westlaw and Lexis, well, all right, but what do you use? You must use something for site checking. You were supposed to site check long before you started using AI. I don't know the answer. Maybe people on this webinar, whether fellow panelists or others, will say, well, you know, a lot of firms have been cutting down on the site checking. Or maybe what happens is there's a policy of site checking, but sometimes a document is filed on an emergency basis and people don't have the time to do that. I don't think I've ever filed a document without site checking. But I just wanted to stress what a massive, massive problem the hallucination issue is, and how embarrassing it can be for lawyers and for experts. The example of the expert was a Stanford University professor, thankfully not in the law school, but a Stanford University professor who, of course, was also likewise very much embarrassed by what happened. To be sure, the real problem is not the embarrassment. The real problem is the possibility of errors in the judicial process, and wasting the time of judges and opposing counsel, and hurting your own clients. Those are the most serious problems. But the one that I think comes home most to us as lawyers is the possibility that this might happen to us and affect our professional reputations. Just human nature being what it is, that's what we care about, and we should care a lot about that. And it just seems so trite to say, well, everybody should site check, but apparently it needs to be said. So that's what I've got for you right now. Again, it's just sort of a friendly addition to the very broad and thorough and excellent presentation we've heard so far.
Well, and I had naively hoped that at this point, a couple of years into this experiment, we would be past the point of lawyers not knowing that AI hallucinations are real.
Yeah, and Judge, I'm very glad that you were the first judge to actually, very early on in this process, to issue an order explaining all this. I hate to say it, hasn't worked well, or at least hasn't worked perfectly. I'm sure it's helped some. Maybe some lawyers read it and did this, but boy, it's like rolling that boulder up the hill and then it rolls back down.
It does, but hopefully the economics will be educational and persuasive. You can buy a lot of Westlaw time for $16,000 in sanctions. So just put it in your Westlaw account instead of your firm sanctions account, and then maybe it's a better use of time. And I will say, going back to 2 points on Stanford, Phil, that you and Eugene, mentioned. I saw a study that came out about a year ago. That was a study from Stanford that asked did a very granular study on 4 different platforms. We had Lexis AI, 2 Westlaw platforms, Precision AI and Ask Practical Law, and then ChatGPT. And its hallucination rates on legal queries were ChatGPT at the top at about 40%. And I think Lexis AI may have been at the bottom at about 17%. So I would say that the rates are improving on hallucinations when you're talking about platforms that are designed for use in the law. But that leads me to start asking Lauren, because he and I have had back channel conversations on this, on his use of AI, because I think we are going to approach the point here soon where maybe we are in territory where we have an obligation as lawyers to start investigating these platforms where hallucinations are a thing of the past, where they are time-saving devices, and then we've got that ethical obligation to make a cost-conscious decision on behalf of our clients. So Lauren, what can you tell us about what you are doing in your practice to interject AI into different disciplines?
We're doing a lot of things, but I think I want to start my answer with why. And the reason is that before I went to law school, I actually sold large mainframe computers for IBM in the early 1980s. And I worked for IBM in the summer of 1981 when the IBM PC was announced. And it became very clear to me in those early days that the PC was going to alter the landscape. IBM management had no idea what they had just done. And they were almost out of business by 1989. It's why I went to law school, because I didn't want to be working for Sears by the end of the 80s. But what I found remarkable is I went through law school with my original IBM PC with 2 5.25-inch floppies and a green screen. And I took that to my first law firm, and I was the only guy with a PC until 1991. And so it took the law profession 10 years for major law, and we were not alone, for major law firms to put a PC on a lawyer's desk 10 years after the announcement. This is happening like in 10 seconds in comparison, what's going on. And what's interesting is that for a very short period of time, I think AI is actually going to get a little worse, because it's being trained on AI generated content right now. And I think that's going to hurt the quality of its responses for a very short time until they figure that out. However, we're extremely close to the point where an AI engine can read its own code and then improve it. And just think about that. If that gets into a cycle, how fast the improvements will come. And as a profession, we're not geared up for that. I mean, if we weren't drag kicking and screaming into the future, we'd all be writing with quill pens still. But and as in a small firm, I view this as kind of a force multiplier. And that for us to compete with the big firms, which we do, we have to have better technology. And we don't need a large library. We have Westlaw. Okay, we're as good as any large law firm library. Who cares? I'll pay the $4,000 or $5,000 a month for that. It's a lot cheaper than maintaining a gigantic library. And I have access, and my associates have access to the same stuff that Williams and Connolly does. And so it's equal footing in that regard. And I view the use of AI tools the same way. And rather than wring our hands about it, we've decided to kind of just jump into the pool and figure out how to use them a little bit. And we talk about it. We have a firm huddle every Monday morning where we talk about what we're doing on this. And you're seeing it already just with regular Westlaw. You get AI generated responses already, and you see it on Google and other search engines. You're getting that already for free. I don't know if it's generative AI or if that's the right term for it, but you're already getting AI type stuff. But one of the first things we did, and we did this about 6 months ago, we used Grok on X. I didn't even know that Grok existed. I'd loosely heard of X as a replacement for Twitter. But I had a local counsel in Miami who was working with me on a case. And we had a very hairy motion about to be decided by a district judge in Miami. And the judge had asked some encouraging questions that was encouraging the people to settle. And in evaluating our settlement posture, we put our briefs through Grok and asked who's going to win. And now this is all publicly filed information, so there was no, client confidences or anything involved. But in 28 seconds, we got a 12-page opinion that looked like it could have been written by about a 6th or 7th year large law firm associate or a very young district judge. Okay, and it was great, and it came out with the right answer too, and that it said it was a close case, but we were likely to win on that, and I was stunned, and I have since used that technique to get ready for oral argument, because you throw the briefs in before an appellate argument or a big motion or something. It's not perfect. It misses things, and like the analysis I don't necessarily agree with, but it really does highlight the tension in the arguments, and it shows nuances that I would have overlooked, because sometimes you get involved, you're a warrior for your client, and you start believing your own BS. You do your own generative AI, and this gives you a little bit of a reality check, and it has helped, because sure enough, that's exactly what the judges were focusing on. So it was really good in highlighting that. Now, we've also had some interesting experiences, with Perplexity, which I like because it shows its sources. One is free, which I like. I think you can sign up for a non-free version, but I haven't seen a reason to yet. But I've asked it, a couple times. A couple of terms. I won't get into the details, but what's the difference between X and Y? And I had done my own research on it. I couldn't really find any satisfying answer to that. And I put it in, and in like 28 seconds, I get a response that was great. And quite frankly, it was kind of what I was hoping for. And even though I hadn't, prompted it to come out with what I was hoping for, but then it didn't cite its sources. And I asked it, I go, hey, great answer. How did you come up with this? And it said, I looked through the sources and couldn't find something directly on point, but this is my synthesis of the available work, which I found remarkable. I found just remarkable. Now, I did a similar thing, and I can't remember whether it was with Grok or with Perplexity, where I asked a similar question, and I got, about a 1.5 page response that was suitable for dropping in a brief, that I thought the analysis was perfect and was very well written, and it had the cases cited with pinpoint sites. And when I went in and did the checking, not one of them was real. Now, not one of them was real. And when the cases, there was actually a case by this site, but it didn't have the same name, and it wasn't remotely on point. And so I don't know where they come up with these things, but the analysis was flawless. It's just I didn't have any sites for it. I had to go out, and so I think you have to treat this. I've been reviewing associate work for almost 40 years on this stuff, and you have to kind of treat it with like you get a memo back or a first draft of a brief from an associate, and it's like the old Reagan days: you trust but verify. You get in there, you look, say, this looks pretty good. I do know this area of the law. I'm pretty sure this is right, but I'm going to have to dig in on a few of these other points. And sometimes they just miss the boat, and I think part of it is because the technology is in its infancy, and part of it is my ability to use it is very much in its infancy. I equate it to the baby grand piano I have in my living room I bought when my oldest son was young, and he learned how to play it, but he's long out of the house, and I have this marvelous instrument I don't know how to play. And I think AI is sort of like that. It can do a bunch of things I haven't even thought to ask it. But I see a time where, like, you're getting ready for it, like I'm in the middle of this deposition, that if you have, kind of a walled garden with all your documents in it, you could ask it to prepare a witness file and sort the documents in order of relevance and by date or all kinds of other stuff. And it will probably do in a couple of minutes what it would have taken a paralegal or a young associate a couple of days to do. And now you might have to go back and check on a couple of those things, but it's pretty good. And then, the last thing I told you about, we use a case management system called Opus 2. And, you know, I spend the money on it and we don't recover it all. It's just part of the service. But it helps organize, you know, a case for trial and for discovery and everything. But it'll let you analyze the documents. It gives you all kinds of, especially for deposition transcripts or long contracts, you know, it has this assist feature and it will summarize the document. It'll give you key points. And it gives you variety. Do you want the standard summary, the brief summary, or the comprehensive summary? You know, and it's the same thing for like summarizing deposition transcripts. I used to do that as a law clerk when I was in law school, working part-time. And I can tell you my summaries were terrible. You know, I'm sitting at a K Street law firm, you know, doing some securities case. I haven't taken securities and I don't know anything about the case, and they asked me to summarize the deposition. It was the worst money anyone ever spent. But in 28 seconds, I get not perfect, but probably better than I would have gotten if I farmed it out to a paralegal or some outside source or even a pretty junior associate. You know, and so we can take it from there as a start to really make it good. So we're trying this stuff out every day because we figure out that we can't, and we spend a lot of time talking to ourselves at least once a week about what's happening to us so that we don't all have to make the same mistakes. So that's what we've been doing.
Well, you are very adept and you're getting more adept despite your awareness that you're not yet adept. So that's positive. I would say on Perplexity, so I had a judge, Patrick Bumate, who's familiar to those in FedSoc circles, introduced me to Perplexity about a year ago. And I like the point that you mentioned, that it does show its sites, but I will echo your statement that you've got to check them. Just because it says they're citations doesn't mean they're real, which is why Professor Volek had the idea in that first court order regulating AI to said that you don't just have to site check the sources, you have to site check against a traditional database. So I think everyone has to be familiar with that process. You can't avoid Westlaw or Lexis. You're going to have to go to one of those sources at some point. But if you have a timed account, then you can perhaps save some time by using a platform that will show you citations and then chasing those down. I am not familiar with Opus 2, but I think the summary aspect is impressive because that did seem to be like a big waste of time when I was at a firm. The associate summaries for associates who have no familiarity with that area of the law are not great and they're expensive. So that sounds useful. I have not seen, but I'm hopeful that at some point we will have more AI help when it comes to discovery and document review, because that was another area where when I was a practicing lawyer, you had no good options for your client. Either you have the litigation team review the discovery themselves and it costs a fortune, or you farm it out and have a team of people completely unfamiliar with the case and with that area of the law go through it, and it still costs somewhat of a fortune, a modest fortune at that point, but the accuracy is lower. And so if there comes a day where we have good AI tools for discovery, I think that will be very beneficial to our clients. Let me ask, I mean, Eugene, Phil, have you all heard of any AI discovery tools that are being reliably used yet, or is that still years in the future?
I have, but I wanted to just make one point. I'm afraid I relied on something much less reliable than AI in my earlier remarks. That is memory. Again, I would never do that in a written document. I'd always check, but in oral remarks, sometimes one does. And that had to do with the magnitude of the sanction. The actual sanction, the highest sanction I've seen is $31,000 for hosting. So I just wanted to set the record straight with apologies for my reliance on poor pre-technological tools.
I will cancel.
But I'm sorry. We're about to hear about the answer to the question about discovery, which I totally agree is a huge potential use case.
Yeah, and I was just going to say that I've certainly heard of tools that allow litigators to identify key documents with AI, because AI learns, you teach it what's important. And, you know, these tools have been around for a while, like I would say close to 10 years, but they're getting better. And what a great way to level the playing field. I mean, you know, when you have discovery is the one thing that really makes litigation prohibitively expensive. So for so many parties, but if you can do with one tool what it otherwise would take multiple attorneys multiple months to do, I think that can really change the game in terms of how expensive litigation is. So
So
it
let me-
seems like that would be a really good way to kind of apply AI productively.
Let me ask one quick follow-up question. Somebody who tries to avoid discovery whenever possible. I do real lawyering, but it's almost invariably appellate lawyering or trial level, just purely legal stuff, and without the discovery. My sense is that for a lot of this e-discovery, one thing that might make AI suitable is that it doesn't have to be perfect, because existing e-discovery isn't going to be perfectly correct. There are going to be some things, going to be some false positives, and there are going to be some false negatives. If you do standard searches on emails, you're going to miss some things, and that's just the reality. So it may very well be that AI tools, the imprecisions that are so bad when you're filing a brief, one made up citations in a brief poisons the whole thing, may not be as serious issues with the discovery, where, yeah, it may miss some things, but if on aggregate it misses fewer than human discovery, and then on top of that is also cost effective, then it seems to me that might be feasible.
Yeah, that's a good point, Eugene. And two points that the ABA made in opinion number 512. First, the degree of verification you're required to do to be competent varies depending upon what you're using AI for. So certainly if you're using it to find cases to submit to the court, that's a high degree of verification that's required. You need to check every case, as you said. But if, as Lauren said, you're using it to generate questions that you might get in an oral argument, then that seems a much different kind of task with a lesser degree of verification required. And I imagine document review, as you said, Eugene, is probably somewhere in between, because it's never perfect anyway, especially if you have a large volume of documents. The second thing the ABA said is that in some instances, you might be able to do your verification with a subset of materials. Now, that wouldn't be case citations. I think it's pretty clear you need to review every case citation traditionally. But if AI is summarizing a number of contracts or document productions, you could have a subset tested and maybe do it the old-fashioned way or by yourself and see what results you get from AI, and then determine whether or not you have a degree of accuracy that's sufficient enough that you can apply it to the whole set. So the ABA made both of those points in opinion 512.
Very good.
One of the things that I've been worried about, I've been lucky enough to win some cases and have attorney's fees awarded. And so I had to file my application for attorney's fees. And I'm waiting for the day where they're going to whack my fee petition because I did not use AI. And you see that right now. Like it's funny, like in downtown Washington, everybody is using e-discovery. But I'm sometimes out in the suburbs of Washington, with state court practitioners. They've never heard of a relativity load file. They just don't, it's like it hasn't happened out in state courts, in these small and medium-sized cases. We had a case where we gave somebody a relativity load file and they filed a motion to compel against us because they said we gave them junk. They had no idea what it was or how to read it. Okay, it was kind of embarrassing, but I think it goes to the standard of care in terms of being efficient for your client and what judges are going to allow. But it kind of reminds me of the old Carroll towing case from law school, the learned hand decision about radios and tugboats. At a certain point in time, if you're not using AI, you might have breached your standard of care as a lawyer because you missed the case, you missed the point or something like that. Because most of these tools are free right now, and so like radios actually cost money in the 1920s. But if you're not using a free tool that can make you better, I don't think we're that far away from a judge saying, why didn't you do that? You would have seen the case.
Yeah, and to your point, Lauren, I've wondered when that day would come as well. I think Phil's discussion makes me realize that at the point that our regulating bodies in the states are saying that you do have this ethical obligation to explore the use of AI and use it to cut costs for your client, that will be the point where I, as a judge, have to grant that request from the party opposing the attorney's fee award because it's too large, because they did not use AI. But there may come a day before that point where it's just so obvious that even if the state regulating bodies have not said it's necessary yet, it practically becomes necessary in the case. So I think that's where all of our lawyers need to stay abreast, because that point is probably going to happen within the next few years. It could happen sooner than I'm thinking. One other thing I wanted to mention as far as AI use in the courtroom, I saw this come up a few months ago. I had a civil asset forfeiture trial. Those are exceedingly rare. And so it's a criminal case that's operating under the civil procedural rules. So the government needs to prove that money was basically used in connection with a crime. The government's argument when it forfeited these funds was that it was the proceeds of drugs. So they wanted to prove that the person they obtained the cash from was a drug dealer. And law enforcement agents use either of two programs to crack a phone, Cellbrite or Gray Key. And when the law enforcement agent was on the stand explaining that he cracked the phone and got all of these images of green leafy substances, the prosecutor for the government, now acting as a civil lawyer, asked, well, did you run it through the new algorithm with the percentage match function? And then I looked over at the defense lawyer, waiting for the Daubert objection, and it never came. And the officer said yes, and it was a 97% match with marijuana. And so we had an AI tool used on the fly in court. What I was expecting was that the Daubert objection would come in, I would kick out the jury, and then the first question on voir dire of the witness would be, okay, what's the methodology that that platform is using? And the officer would say, I don't know, it's proprietary. Daubert objection sustained, right? And so just because even if you're a Luddite and you are not using it, it doesn't mean your opponent won't use it. And you've got to be ready and on your toes to figure out what the methodology is and if it's reliable enough to be admissible in court. So we're seeing it in court. We will see it in attorneys' fees, applications, and fights later on. We're seeing it in terms of expert testimony. Okay, so any other comments before we move on to a few of the questions we've had submitted?
I just have a question on because I've cross-examined case agents and government experts who have used Cellebrite, and they talk about their background. They took some course, but all their course is they gave me this CD and I put it in the computer and I ran it. They have no idea what happened. So you're using the CD as expert, and so, but I never really thought to do a Daubert challenge on that, but I will the next time I do that. So, yeah.
The only other thing I wanted to say was there's been some mention of free programs, and that's a good thing. But a couple of the state ethics opinions denigrate that as along the lines of, look, you need to verify output, especially if you're using a free program. So I don't know if the free programs are less reliable. If you pay for the upgrade, you get a better product. But certainly some of the state ethics committees think that's the case.
Well, and that's a distinction that Professor Volek taught me 2 years ago, right? If you're paying nothing for it, the question is, how are they getting into Westlaw and Lexis? And then what are they doing with your data, right? How are they making money? And so I think sometimes we'll use that free program assuming that they've gotten a license with Westlaw for free and that they're not making money off of assimilating our data, and that both assumptions are patently false. That's not to say there's nothing good coming out of a free program, but you've got to think through it in terms of confidentiality that you raised earlier, Phil, and in terms of how reliable is the output, and can you site check it against a traditional database. Okay, so let me raise one of the questions that our listeners had, and this is probably targeting you, Eugene, because they are referencing whether or not you should blog about this. Okay, so the listener is saying, are any others regularly submitting draft motions and memoranda together with opposing party motions and memoranda to an AI platform like I am, and then asking it to generate an order as if it were the judge? And so, Lauren, you touched on this earlier with doing this with Grok. And so the real question here is that a worthwhile use of AI? And then I guess we should differentiate on drafts versus filed, publicly available things. Eugene, do you want to take the first crack, and then Lauren, you can supplement?
I haven't done that. I will now. I think it's a great idea. Here's one way of thinking about AI right now. AI is kind of like a really smart summer associate. I think we've had them before. Do you trust them? Of course you don't trust them. You're a lawyer. You don't even trust senior partners because you trust no one. But in particular, you don't trust summer associates because they've got lots of gaps in their knowledge and in their judgment. At the same time, they'll sometimes give you something interesting, perhaps in part precisely because they don't have your experience, they don't have some of your blinders. So as a result, you might ask them and they'll say, oh, how about this? And you say, okay, fine, that's interesting. Of course, you could also ask them to write a draft, and then sometimes it'll be pretty good, but you have it all checked and you rewrite it as necessary. So likewise, it sounds like a great idea because what I think it might do is it might open your eyes to something you're missing. Now, I think it's a mistake. I've seen some people actually, like, speaking of blogging, post something, say, well, I asked AI this, and here's what it told me. My question is, I saw it actually in a law review article. I said, why are you saying this? It doesn't matter what the AI tells you, at least as some conclusive matter or even some evidence of what is actually true. But it could provide a useful insight that you say, look, I could totally see the judge issuing this opinion and focusing on this point that he read in the other side's memo. And on reflection, or emotion, excuse me, let's say motion. On reflection, I realized my response didn't do a great job of it. So I'm going to beef up the response. Then if I resubmit the motion with a beefed up response and the AI still says, oh, we rule in favor of the motion and ignores my beefed up response, I'm going to panic and say, oh, well, the judge will do the same. At least at this point, the judge is not an AI. The judge will have his own reactions. But at least the initial pass might give me a perspective on something that I missed. Because as you pointed out, it's certainly possible, it's not even possible, it's sort of psychologically likely that we as lawyers miss certain kinds of things. And if the AI can open our eyes to that, that's pretty useful, so long as we realize its limitations.
Lauren, what do you want to add on that?
Yeah, I agree with it. I mean, the issue is drafts. We ran publicly filed stuff through, and so we actually thought about this stunningly, and ran the publicly filed stuff through. I think my answer on drafts is it depends on whether there's any, client confidences or other confidential information in there, because you might not read. I mean, you have to. All the federal courts here make you redact certain things. If you put an unredacted document through AI, like with a social security number or something like that. So there's lots of things you need to be kind of careful about. But on purely legal arguments that didn't have any I wouldn't have any hesitancy about running a draft through there, just to see what happens. And because I have found it great. I mean, the one thing about being a smaller law firm is you have fewer people to bounce ideas off of. And to have another person around, it's not really even a person, but another entity, to bounce some ideas off. You might see things you didn't see. I can only think that's useful.
Phil, do you want to add anything on this discussion on uploading drafts?
Yeah, I do think you have to be careful, even if it's just legal argument, whether or not you're revealing mental impressions you have about the case that would otherwise be protected, and whether if somebody else got access to that, they would obviously know kind of your playbook, and that might be something you don't want. So if you have some arguments that maybe even the other side's arguments, you certainly wouldn't want to reveal information that you've developed in your own strategy to the adversary. So I would be careful about mental impressions, and I do think some of the state's ethics opinions make that point. It's not just about client factual information, but also strategic things that you might have that really should be regarded as privileged and confidential.
And let me ask this for Phil and anyone else. We've got a follow-up question from someone on what happens if you upload privileged information into AI, but it never uses that information or spits it out to another user. Has there been a breach of the duty, or is there an argument that AI is your agent? And I think this question got me back on the line of thinking of paid versus unpaid platforms. I know that's too rough of a distinction, but for example, if I'm working with a Westlaw AI, I might have less reservation than working with a ChatGPT on uploading a draft or uploading privileged information, because I never heard of anyone making the argument that a lawyer loading a search term query into Westlaw then removes the privilege on it and it's discoverable, right? Because in that instance, you having the Westlaw account makes it your agent, and so you're using it in your attorney-client relationship. So what thoughts do you have, Phil? And then we'll open it up to Lauren and Eugene on paid platforms versus unpaid, or is there any harm at all if you upload privileged information, but no one ever knows?
Yeah, so one of the ethics opinions from one of the states pointed out that this was an issue, and it said it was beyond the scope of the opinion. and kind of indicated it was a hard question. I do think the answer is going to turn not on whether or not it ends up getting used, but what the expectation of confidentiality is with that platform. So if you do load something to ChatGPT under policies that say, we're entitled to use this information, we can use it with other people, we can disclose it, we're going to improve our product, then I think there's a very good argument you've waived the privilege, because you have basically disclosed that information in a way that you do not have a reasonable expectation of confidentiality. And that's enough to waive the privilege. So I don't think it matters if it isn't waived, but it probably does matter whether you have, if you have a contract with a vendor, and under that contract, you're assured that this is going to be treated confidentially, then you probably have a good argument you didn't waive. So I think it all depends what your expectation of confidentiality is when you upload it reasonably.
Lauren or Eugene, do either of you want to add anything on the no harm, no foul question?
I know in DC, you have to treat the privilege like the crown jewels. That's what the DC circuit says. And so I think if you upload it, like I agree with Westlaw that your search terms can't possibly be, but if you upload something like Grok or ChatGPT, I mean, they train on that information. How can you say they're not using it? I don't even understand that. The only way I can think you do it, like on Opus 2, we have kind of a walled garden for our case. And so I don't have any compunction about you making queries and that. No one else can get to it. That's just our data. So I don't think it's paid versus not paid. It's what happens to it afterward. If it's in the hands of a third party who isn't like your agent, your paid agent with a duty of confidentiality, I think there's a very good risk that you waived.
Very good. Okay, Eugene, let me ask you this. You brought up that a lot of our hallucinations we're seeing in court cases are from pro se filings. We have a listener ask, has there been a improvement noted in pro se pleadings or filings? I'll let you say anything you want to on that, and then I'm happy to share my thoughts as well.
So, I don't have enough of a perspective like before and after. I'm always hesitant when people say, well, things better now than before. I say, well, I don't really know fully what things are like now. And I certainly don't remember, never looked into it when they were before. So we only see little corners of the world, generally speaking, unless we're doing a really thorough survey. I have seen documents that I have every reason to think were pro se generated by AI and probably would have been much better than the ones before that were filed before. At least among other things, AI produces material that's quite grammatical. So obviously, if it's nonsense, then it's not terribly helpful. But at least it'll be easier to read and lack the extra unpersuasiveness stemming from ungrammatical text. So I think it's probably better. I do think that some, at least pro se's, at least know enough to check, and a lot of the citations can be checked through online free sources like Google Scholar and the like. I wonder if it might be worthwhile to have a specific order in pro se cases that is very short, that is issued in every pro se case, where presumably, and maybe even kind of with a docket entry saying important to read or something like that, saying we're aware that certain pro se's are using AI. If you choose to do that, make sure you understand that you need to check every source and that there are online resources like Google Scholar. A lot of people probably don't know about it, that have a very great many legal sources that appear to be sufficiently reliable. So I think that might be helpful, because I think lawyers, I'm hoping, are going to learn some more about this, although I'm shocked they haven't yet. But pro se's are going to keep doing this and presumably doing it more and more often because they don't really have a choice.
And from my vantage point, I don't have a wealth of data on it, but I certainly have some, having seen pro se's before and after generative AI. Our rule in the Northern District requires individuals or lawyers to disclose their use of AI. Some of them do. A lot of the pro se's don't. But I would say there's an uptick in the number of pro se filings that at least get the elements of the motion that's at issue correct now, and they used to not. They used to complain or vent, but not know what elements they have to prove. So I would say there's an improvement there. And that is wonderful uses of generative AI, is giving access to people who otherwise don't, but that doesn't mean it's always right. Phil?
Yeah, do your disclosure requirements apply even if somebody uses AI just to make their brief a little better, like more grammatical, as Eugene said. And I ask that only because I could see, apart from all the uses that Lauren described, I could see a bit of a stigma that lawyers might believe attaches to a brief that is composed in whole or in part with AI. So while I might want to use AI to help me sound better, I probably wouldn't do it if I had to like disclose to the court that I did it.
Yeah, that's a great question. So I can tell you my view. I'm one of many judges on my court, but my view is if you use AI to make your brief better, I wouldn't expect you to disclose that. If you use AI to draft part of the brief, I would expect you to disclose that. What we're really looking at is the hallucination and the bias side effects. And if it's just making grammatical improvements or streamlining an organization, I'm not concerned about hallucinations or bias there.
So, Judge, I appreciate the distinction when we're talking about just like if somebody just runs an introduction, let's say, without any citations for grammar checking. I have heard it said, and I've heard it said in filings by people who try to explain why their filings contained hallucinations. So maybe they're just exaggerating to cover themselves. But I've heard it said that hallucinations are sometimes introduced when a document is submitted to an AI software with instructions of improve it or edit it or proofread it or whatever else, or turn the citations into Blue Book form. The citations end up in Blue Book form, but they correct citations end up becoming incorrect. Again, how often that happens, I don't know personally, but it is certainly possible that you take a document that was all human written and you submit it to AI simply to improve it or proofread it, and it will correct citations.
That's frightening. So thank you for scaring me yet again. You do it every time we talk. Okay, well, I just want to thank FedSoc on behalf of the panelists here for letting us get together and hash through some of these important issues. Kyla, I'll hand it back to you.
Thank you so much. I'm sorry to have to wrap up, especially since I'm sure we could go on for another hour with all the interesting pieces of this discussion. We really appreciate you as the panel joining. Thank you so much for taking this section of your afternoons and sharing your expertise and insight. Thanks also to our audience for joining and participating. Welcome listener feedback by email at fedsocforums@fedsoc.org. And as always, keep an eye on our website and your emails for announcements about other upcoming virtual events. With that, thank you all for joining us today. We are adjourned.